24. Dr. Arnold Kimia Mamadi, Godfrey Oyaro, Eugene Wandera Amalwa, Wesley Nganga, Sunday Umbisa Mwangi, kindly follow Sada, Vincent Juma Munyera, Laura Naliaka Kisaka, Eddie Mirera, Simon Kiama, Anastasia Njeri Kaburi, Dalton Benson Amokua, Salva Construction Limited.
When we are praying before the accused persons are admitted to bond, a pre-bail report to be a bail report. For the reasons, Your Honor, that these offences occurred all over the country. This matter is not domiciled in Kakamega. It's a matter that emanates from Vihiga County. The accused persons come from all kinds of work, and some of them, Your Honor, we do not know their places of abode. Your Honor, for example, accused number 3 was informed to attend court today because we were relying on mobile phones, and at this point, he has switched off all his mobile phones. We are not able to reach him, and for that reason, he is absent. And it will be important to have a pre-bail report so that at least we know the places of abode for the accused persons and if they are flight risk. I'm also asking, I'm also praying for a warrant of arrest in respect of the third accused. If the court is minded to admit them to bond right away, I'm praying for very stringent bond terms. For the reason that the public lost a colossal sum of money, and generally offences of corruption are very serious in nature, hence our application for stringent bond terms.
Your Honor, bail is a constitutional right. Bail and bond is a constitutional right. And the accused persons are innocent until they are proven guilty, Your Honor. The reasons that the prosecution is advancing as to why the accused person should be denied bail or put under stringent bond terms have no bearing in law, Your Honor. The fact that the accused persons are from different walks of life is not a consideration in granting bail or bond. Secondly, Your Honor, the prosecution is saying that they do not know the places of abode of the accused persons, yet they arrested them and brought them before this court. Meaning they conducted investigations before availing them to court. Your Honor, part of investigations is establishing where the accused persons come from. So they cannot tell us that they've arrested and charged the accused persons, and it is now that they want to go and find out where the accused persons come from. Your Honor, the other reason that is being advanced is that the public lost a lot of money. Your Honor, the accused persons also have rights available to an accused person at the point that they are being charged. So that alone cannot be used to take away their rights to a fair trial. Another issue, Your Honor, is that nothing has been availed to this court to show that the accused persons are flight risks. In fact, the prosecution is saying they want to go and establish whether the accused persons are flight. So, Your Honor, those reasons that are being advanced have no bearing in law and have no anchoring in law. We are praying that the accused persons be admitted to bond terms, favorable bond terms. There is nothing that the prosecution is bringing forward to show why the terms should be stringent, Your Honor. Secondly, Your Honor, we are praying that we be supplied with the charge sheets, witness statements, and all other documents that the prosecution is intending to rely on for us to be able to prepare for the trial. Thank you, Your Honor.
The respective learned defense counsel then applied that each be released on bail bond on reasonable terms. Ms. Osoro, learned prosecution counsel, urged this court to first call for pre-bail reports before setting the bail bond terms, arguing that A, some of the accused persons' places of abode are unknown and they were traced using their mobile phones. B, that the accused persons are charged with offenses under the Anti-Corruption and Economic Crimes Act, which are very serious. And C, that the amounts of public funds involved in the case are substantial. Learned counsel for the respective accused persons did point out that the prosecution has not adduced any evidence to support the averment that any of the accused persons' places of abode are unknown or that any one of them is a flight risk. It was pointed out that some of the accused persons were summoned to report to the EACC offices at Kisumu yesterday, and they honored the summons, while others were aware that the EACC officers were on their way to arrest them at their places of work and yet did not flee. It was also pointed out that at this stage of the case, each of the accused persons is innocent until such a time as the court will pronounce their guilt. It is now settled law that after an accused person has been charged in court with a criminal offense, he or she is entitled to be released on bail or bond terms, on reasonable terms, and that the only time that this right can be taken away is where the prosecution is able to demonstrate to the court that there are compelling reasons that warrant the right to be taken away. This right is provided for in Article 49, Sub-Article 1G of the Constitution. Until the prosecution has raised grounds that would seem to indicate the existence of compelling reasons, the court must therefore assume that a person brought before it with a criminal charge qualifies to be released on reasonable bail bond terms. In other words, it is only after the prosecution has placed before the court sufficient material to warrant an inquiry into the matter that the court can call for a pre-bail report. In all other circumstances, the court must set the bail bond terms. Ms. Osoro also called the court, if minded to set bail bond terms, to give what she terms as stringent terms. Unfortunately, that term is not contained in Article 49, Sub-Article 1G of the Constitution. The word used is reasonable, and the use of stringent terms would obviously be unconstitutional. I do not wish to go into the argument of what amounts to reasonable terms, but I only want to say that in my view, that term must mean what is fair and just, and makes sense in the face of the present circumstances, and is not exceedingly high nor exceedingly low. And thus, after careful consideration of the submissions by both the prosecution and the defense counsel, I am indeed minded to grant each of the accused persons a bond of Kenya shillings 1 million with one surety of a like amount, and in the alternative, a cash bail of Kenya shillings 300,000, and it is so ordered. The bond is 1 million shillings with the surety of a like